Buenas tardes a todos y bienvenidos. Soy Anna O'Connell, presidenta de ADA, y estoy encantada de que todos nos acompañéis hoy. Antes de empezar, quiero dar las gracias a la Fundación Giner de los Ríos por aportar este espacio y en especial a Estela Jiménez. El evento de hoy trata sobre las obras de arte expoliadas por los nazis durante la Segunda Guerra Mundial. Es un hecho muy triste que en cualquier guerra la propiedad cultural sea saqueada o destruida. Esto ha sucedido a lo largo de la historia de la humanidad, desde la época de los vikingos, las cruzadas y el Imperio Británico, y continúa hasta ahora. Muchos museos y edificios históricos en Ucrania han sido saqueados tras la reciente invasión rusa. Así que el saqueo de arte en la guerra es tan antiguo que la propia guerra. Por tanto, no es de extrañar que los nazis expoliaron obras de arte durante la Segunda Guerra Mundial. Sin embargo, lo que es insólito es la magnitud de ese saqueo. Los nazis fueron responsables de la mayor confiscación de obras de arte en la historia de la humanidad. Durante 12 largos años, a partir de la llegada del partido nazi al poder en 1932, se apoderaron o se coaccionaron la venta de una quinta parte de todo el arte occidental existente en Europa en ese momento. Así que saquearon millones de obras de arte, solo en Hungría 1 millón. Así que la escala del saqueo fue única. Además, ese saqueo no fue consecuencia de la guerra, no fue un daño colateral. Fue una política oficial nazi y una parte clave de su proyecto genocida y racista. El saqueo se utilizó para degradar el pueblo judío y privarles de su lugar en la sociedad. Según palabras de un historiador, se tomaban los objetos que pertenecían a las víctimas y este los hacía parecer menos humanos, menos cultos, menos como tú y como yo. Y ese saqueo precedió a la deportación y la deportación llevó al asesinato. Así que el saqueo fue un giro muy importante en el retorcido camino hacia Auschwitz. Así que había una fuerte conexión entre el saqueo de obras de arte y el Holocausto. Los nazis trataron de redibujar el rostro cultural de Europa, reordenando o destruyendo sus grandes obras de arte. Algunas dirán que en tiempos de guerra, cuando se pierden vidas, cuando las familias se convierten en refugiados, ¿por qué deberíamos preocuparnos tanto por las obras de arte? Yo creo que la respuesta le podemos encontrar en esta cita de la UNESCO. Algún día la guerra terminará, algún día la gente volverá a sus hogares, de alguna manera se reconstruirán las vidas destrozadas y las obras de arte reflejan la identidad humana. Su restitución contribuye a reconstruir comunidades rotas y ayuda a las personas a restablecer su identidad y los vínculos a su pasado. Hoy vamos a escuchar a dos expertos en esta materia que nos van a guiar a través de la historia del saqueo por parte de los nazis y de las reclamaciones presentadas por los supervivientes y sus descendientes para recuperarlas. Steve Schindler es un socio fundador del despacho de abogados Schindler Cohen Hochman en Nueva York. Es el bufete líder en Estados Unidos en Derecho del Arte. Steve fue presidente del Comité de Derecho del Arte del Colegio de Abogados de Nueva York y él también forma parte de la facultad de la Universidad de Nueva York, donde enseña Derecho del Arte. Steve además es copresentador del podcast The Art Law Podcast, que os recomiendo muchísimo. Antonia Bartoli es Curator de Provenance Research en la Galería de Arte de la Universidad de Yale y posteriormente ha sido Spoliation Curator en el British Library en Londres y investigadora de restituciones para Christie's en Nueva York. Steve, Antonia, it's such a great pleasure to have you both here with us today. Thank you so much for making the journey. The presentations of Steve and Antonia are going to be in English, and we're going to start with Antonia, who's going to give us a brief history of looting during the Nazi era. So, muchísimas gracias a todos por venir, y sin más quiero dar la palabra a Antonia. Gracias.
Thank you, Anna. Good evening, everyone. I will just jump right into it then. Between 1933 and 1945, the Nazi regime was responsible for the confiscation, destruction, looting, and coerced sale of hundreds of millions of art objects and other items of cultural, historic, and religious value from public and private collections throughout Germany and Nazi-occupied Europe. I believe one of the words that I understood from what you said, Anna, was magnitude. A facet to the systematic religious and racial persecution of European Jews and others deemed enemies of the state, the pervasive looting of cultural property also fed the insatiable collecting appetites of Adolf Hitler, his second-in-command Hermann Göring, and others of the Nazi elite. Dubbed the greatest art theft in history, over 75 years, almost 80 years later, collections and claimants are seeking to recover an approximate 100,000 items still missing. Concurrently, some government bodies, public collections, and parts of the trade are working to identify objects in their possession that changed hands during this period. Tonight, Steve Schindler and I have the privilege of walking you through a brief history of the losses and efforts at recovery and restitution, past and present. To give you an outline of the direction our talk will take, I'll provide a brief overview of the mechanisms and tools by which the Nazi regime appropriated art and the Allied forces' efforts to identify, recover, and restitute objects lost or displaced in the post-war period, whether at the hands of the Nazis or others. Stephen will then consider more recent efforts by modern nations and some museum collections following the 1998 Washington Conference principles, including the situation in US courts. I'll finally conclude with a reflection on a group of paintings from my own collection at the Yale University Art Gallery and show how one museum has approached these issues from the past 40 years to the present day. First, a closer look at the history of looting. The looting of Jewish and other enemy property was a key part of the Holocaust. Thefts and the coerced sale of art were carried out from 1933, shortly after Hitler became chancellor. The robbery and murder of Max Silberberg, a German Jewish entrepreneur, collector, and patron from Breslau, has been described as a model case of Nazi persecution by historians. When the Nazis came to power on January 30th, 1933, Silberberg's position changed almost overnight. He was forced to resign from all his public offices, and in 1935, a member of the SS took control of his family villa, forcing the family out and selling the villa well below market price. Silberberg moved with his family into a small rented apartment and was forced to part with the majority of his art collection. We can see the title page of the forced sale of his collection on the screen at the Paul Kraupe auction house in Berlin, discreetly referred to as an important Silesian collection with all record of Silberberg erased. Again on the screen, one painting from his collection, a vibrant landscape by Gustave Courbet, Photographed and featured in the auction, while other names are mentioned in its ownership history, Silberberg once more is erased and not acknowledged. As with other paintings in the sale, funds for the painting were placed into a blocked account and inaccessible to the Silberberg family. The painting disappeared when it sold into private hands. In 1940, other artworks were sold under duress by Silberberg to the Silesian Museum of Fine Arts, and at the end of 1941, Max and his wife Johanna were deported. In May 1942, they entered the Theresienstadt ghetto. Various historians assume that Silberberg and his wife were murdered in Auschwitz, but we might never know the full history. After the Second World War, his son had both his parents declared in May 1945. These forced sales, or sales under duress, were not unique to private collections. For business owners, in a process called Aryanization, Jewish-owned businesses were transferred to non-Jews. This was the fate of antiquarian book dealer and art collector Jacques Rosenthal. Jacques Rosenthal was the owner and proprietor of the Antiquarian Bookshop in Munich and a private collector of early modern European globes and Renaissance paintings. We can see here on the screen the interior of his antiquarian bookshop with floor-to-ceiling shelves of rare volumes decorated in the background by early modern Renaissance globes. In 1935, Rosenthal's firm was Aryanized and transferred to non-Jewish ownership. Works of art from his Munich apartment and also in Paris were confiscated or forcibly sold or sold to fund his wife's flight to Switzerland. An image on the screen shows a happy occasion from the Rosenthal family's history, the wedding of his son, and we can see pieces of his artwork in the background. At right, we see one of those paintings as it was photographed following confiscation, the Aryanization of his firm, and full liquidation of his assets. These forced sales, sales under duress, essentially sales at gunpoint, and Aryanizations were only one such mechanism by which the Nazi regime oversaw the wide-scale plunder and displacement of cultural property. As the regime gained power throughout the 1930s and into the 1940s, designated task forces specifically for confiscating Jews' assets were created. One such looting task force for confiscating cultural property was the Reichsleiter-Rosenberg Task Force. Founded in 1940, it was led by the chief ideologue of the Nazi Party, Alfred Rosenberg. Between 1940 and 1945, the ERR operated in France, the Netherlands, Belgium, Poland, Lithuania, Latvia, Estonia, Greece, Italy, and other territories of the Soviet Union. The image at the right of the screen captures these wide-reaching arms of the ERR's operations around 1942. In France, the ERR confiscated 40,000 works of art from Jewish collections alone. We can see in the Room of the Martyrs at the Jeu de Paume Museum in Paris these paintings piled one on top of another before they're transferred to Germany. Some of these paintings were sold off to the art market to fund the Nazi war machine. Others were handpicked by Hitler and Hermann Göring. At right, we see Hermann Göring examining paintings by Matisse that had been plundered from French collections. Similar looting task forces also operated across Germany, Italy, the Netherlands, and Austria. Again, while some objects were recycled and sent to the art trade to fund money for the Nazi war machine, others continued to be selected for Hitler's planned Führer Museum in Linz. Although never fully realized, Hitler tasked agents, dealers, curators, and art historians across Europe to identify and acquire masterpieces of European art with the vision to showcase the best of Western artistic production in his hometown. We can see here on the screen an image of the Kunstschutz in Italy, a specific division under Hermann Göring with paintings seized from museums in Naples. One collection seized by military forces in France, transferred to the Jeu de Paume, and selected for Linz was the Schloss collection. Formed by German haberdasher and collector Adolf Schloss and his wife Lucy Mathilde, the couple acquired over 300 works of art. Layered one on top of another on these high walls underneath vaulted ceilings, the paintings were exhibited publicly in a salon style at their residence in Paris. After Adolf died in 1910 and Lucy in 1938, the collection was inherited by their children. Scarcely a year later, in 1939, at the outbreak of World War II, the heirs stored the collection for safekeeping in the countryside, miles away from Paris. In 1940, after the invasion of France, German units were charged with locating the famed collection. In 1943, Vichy officials and German SS officers seized the collection. 2 of the Schloss children were arrested. The collection was taken to Paris and stored in a bank where an inventory and valuation was drawn up. 49 paintings were sent to the Louvre and 262 were sent to the Jeu de Paume. The majority of these were then passed on and sent to Hitler's offices in Munich. And we can see here Hitler and Goering examining paintings, including one at left from the Schloss collection. If we look closely at the photo of the right, we see one painting from the Schloss collection, View of Alkmaar, now at the Yale University Art Gallery. On the back of the painting, markings and labels tell us how it moved from Paris to the countryside, back to Paris, up to Munich. The number 15 on a piece of paper fixed to the back of the panel is the crate number where the painting was stored in Munich before being delivered to Hitler's offices. The Lankoronski collection, Vienna, was another collection handpicked for Hitler's Linz Museum. Descended from a Polish noble family from Galicia, Karol Lankoronski, pictured with his son, Anton, assembled one of the most important private collections in Austria of Italian, German, French, and Dutch paintings, which he displayed in his home along with antiquities, bronzes, sculptures, porcelain, and glass miniatures. When Count Karol died in 1933, his children inherited the Palais, which we can see on the screen here, with its exceptional collections intact. In light of the growing unrest in pre-war Europe, the Count's heirs attempted to transfer the collection to Poland. This required special dispensation from Austrian authorities because of strict laws governing the export of art belonging to Jews. However, after the German invasion of Poland in September 1939, the family were deemed enemies of the state because of their Polish origins, and before the collection could be exported, the properties in Vienna were confiscated by the Gestapo. While some works from the family's collection were coveted for the private collection of Goering, they were also coveted, of course, by Hitler. Many were transferred to Germany with the intention that they end up in Linz. We can see on the back of this painting, again, clues as to its origins. The stamp of the Federal Monuments Office, which had approved the painting's transfer to Germany, to Hitler. However, underlining the voracious appetites of each of these leaders for work, we see correspondence between the curator of Hitler's collection and an officer on behalf of Goering battling over where the painting should end up, with Goering in Munich or with Hitler in Munich. And in the space of 3 years, the painting was transferred between 4 different depots. While the majority of art loss and theft between the years 1933 and 1945 was instrumented by the Third Reich, it was not exclusive to it. At the end of the war, Allied and Soviet forces, as well as civilians, were responsible for theft and plunder. The Soviets, as retribution for cultural destruction within territories by German forces, delegated what became known as trophy brigades. Dispatched in 1945, they traveled throughout Germany, as well as recently liberated countries, to find the cultural valuables that could be taken as compensation. While German cultural institutions were targeted, the trophy brigades also requisitioned property that had been spoliated by the Nazis and left behind. We can see a before and after of the Reich Chancellery in Berlin about 1942 and then in 1945. In 1942, as it stood full functioning. In 1945, after it had been sacked, paintings ripped from the wall, objects taken from storage by Soviet troops. On the screen as well is a reconstruction from 2013 of the Green Cabinet of painting galleries of the Kunsthistorisches Museum in Vienna. The images in black and white show paintings that had formerly been on loan to the Reich Chancellery from 1938, and among many others, from private collections, from public collections, were lost or presumed destroyed in 1945. These thefts of the Allies, however, were perhaps the exception rather than the rule. And when the Western Allies came across numerous repositories throughout Germany and liberated territories within Europe, filled with the cultural property the Nazis had systematically plundered, a specialist unit called the Monuments, Fine Arts, and Archives section of the Civil Affairs and Military Government of the Allied armies, more commonly known as the Monuments Men, were tasked with sorting and classifying the material, and where original owners could be identified, restituting the items. We can see here officers of the Monuments Men recovering a Rembrandt painting from a salt mine in Austria, where at the end of the war, the Nazis deposited the plunder that they took. At right, we see the Munich Central Collecting Point, a central collecting point in the American sector of Germany. It was a depot used by this division at the end of the war to process, photograph, and redistribute artwork and cultural artifacts that had been confiscated by the Nazis and hidden throughout Germany and Austria. Both the Schloss painting and Lankoransky paintings passed through the central collecting point Munich. The Schloss painting, after having been stored at Hitler's offices in Munich, was among paintings raided by civilians during the final days of the war. A letter on the screen at left describes an interview with a Munich local, Josef Frank, who had found the painting in the cellars. When probed for further information, he had explained he had been hoping to trade the painting for food, clothing, money, and schnapps. Ultimately, the Monuments Men recovered the painting. It was transferred back to France and returned to the Schloss family before coming to Yale. The Lankoransky painting similarly was recovered by the Monuments Men at salt mines in Austria and transferred to Munich. On the back of the painting today, we can see inventory numbers in blue and red crayon corresponding to the painting's transfer from the salt mines to Munich, back to an Austrian recovery depot, and finally back to the collection in Vienna in 1947. The research of the Monuments Men was not, however, comprehensive, nor were they able to identify former owners. Likewise, they were just one branch within the Allied forces, and in the immediate aftermath of the war, there was no agreement among the Allied victors occupying Germany and Austria regarding restitution. As a result, displaced cultural property was managed in different ways. In instances where original owners were not able to be identified and the items restituted, they would be repatriated to their presumed country of origin. Indeed, we returned to the Courbet from the Silberberg collection. In lieu of its return to the Silberberg collection, the Courbet was transferred to the Hamburg Kunsthalle. In the final days of the war, the painting was discovered by British forces with a Berlin housekeeper, Ingrid Gardner, fleeing the city to Scandinavia with 5 paintings clutched in her arms, rolled up. Where she had acquired the painting was at the time unknown, and with the absence of any evidence, the painting remained in Hamburg. The painting would only be discovered years later, simultaneously by the Silberberg heirs, as well as the owner from whom Gardner had safeguarded the painting, a Dr. Herbert Schaefer from Berlin, who had recently moved to Malaga. In 1970, the Hamburg courts reached a resolution where the painting was restituted to Dr. Schaefer, who paid partial compensation to the Silberberg heirs for their loss. Looking beyond the Courbet, other items that were sold on the market or otherwise changed hands have similarly continued to circulate, ending up in public or private collections on the market, and as the 1940s drew to the close, divisions between East and West grew. The Allies shifted their attention to prioritize Cold War politics in lieu of identifying and returning these assets. On the screen is a selection of paintings from the Silberberg collection that remain missing today. paintings from the Rosenthal collection that remain missing to this day, and finally, the Schloss collection. Of the 333 paintings acquired by Adolphe and Lucy, in 1998, 171 remained accounted for. Bringing us closer to the present day, with the opening up of the East in the 90s, it's brought greater attention to objects and archives previously thought lost. Renewed attention brought to the period 1933 to 1945, followed with a multitude of claims for objects and these issues unaddressed. When 44 governments convened to develop a consensus on non-binding principles to assist in resolving these issues relating to Nazi confiscated cultural property, which Stephen will tell you more about.
That's great. Thank you, Antonia. That was a great setup. And just so you know, I'm putting on my timer here because I could do this all night, and I know that's not what you signed up for. Okay. Okay, well, good evening, and thank you, Anna, for the introduction, which I did understand, and to the ADA for inviting me to speak to you tonight in this spectacular setting. My aim in 45 minutes is to give you an overview of the post-war restitution efforts in the US and examine several of the major restitution cases beginning in the 1990s through today. I must warn you, though, that I am going to be talking about the law. Unfortunately for the heirs of Holocaust victims, parties resisting restitution of looted artworks have often relied on technicalities of the law. So I'll have to talk a little bit tonight about those technicalities, but I'll try not to get us all lost. The United States is what we call a common law country, a system of jurisprudence that we inherited from Great Britain. Unlike most of continental Europe, South America, and Asia, whose laws are mostly contained in voluminous codes that you inherited from the Roman Empire, US law is shaped by judicial decisions. So the cases that I will be discussing are important not only because they change the lives of the parties involved, but also because they may change the lives of those whose cases have not yet been heard. One of the things I always tell my students at the start of every term is that while we read judicial decisions, or cases as we call them, to learn about the law, and while these cases sometimes can seem a little bit dry and remote, they are always about people, and often people whose lives have been profoundly shaped by these legal decisions. And I'm going to try my best here to honor those lives. So before we can talk about the rise of legal restitution efforts in the United States in the late 1990s, In the late 1990s, we need to reflect first on what happened in the roughly 5 decades after the end of World War II, and Antonia has given you some of that information. She told you about the remarkable efforts of the Allied forces to return plundered works recovered from the Nazis after the war to their countries of origin. But by the late 1940s, the so-called monuments men returned home, and the efforts of the Allied governments to return looted works ended. And although some of these works were ultimately restituted to their owners, many were not. By the 1950s, a lot of these looted works started to come back onto the art market in Europe, particularly through sales in Switzerland. In those years, works were consigned to galleries by sellers who had plausible theories of how they obtained the works. Very few questions were asked, and many of these works ended up in the United States, in both private collections and, yes, in our museums. Now, in this post-war period, there were very few lawsuits either in the US or in Europe, and there are several reasons for this. First, the owners were either dead or geographically dispersed. The Holocaust was still a relatively recent event, and locating art lost was not the highest priority for those displaced and often traumatized individuals. Second, there was no technical way by which artworks could be easily traced. In this pre-internet world, There were no databases or even easily accessed central repositories of information about stolen works. And third, the Cold War accelerated soon after World War II ended, and the Western Allies began to turn their attention to the new conflict and away from Nazi Germany. Also, a lot of the records documenting Nazi looting were pulled behind the Iron Curtain and off limits to Western scholars. So then in the 1990s, things started to change. Of course, in 1991, we saw the collapse of the Soviet Union. And in that same year, Lynn Nicholas published her seminal work, The Rape of Europa, which put into sharp focus the details of Hitler's vast enterprise to strip the continent's Jewish population of their art. And with increasing access in the West to Nazi records, scholarly articles started to appear, exposing the enormous scope and scale of Nazi looting. And then in 1997, the exhibition Egon Schiele, the Leopold Collection, opened to great fanfare at the Museum of Modern Art in New York and featured Portrait of Wally, a work taken by the Nazis from a Jewish art dealer in Vienna. The story behind the Portrait of Wally case is this. Leo Bondi was a Vietnamese art dealer who owned a gallery called Wertel & Sons. After the annexation of Austria in 1938, a Nazi functionary, Frederick Welz, Aryanized her gallery, and you heard Antonia talk about the process of Aryanization. He later told her, he came back and he told her he also wanted a picture that was hanging in her home, Schiele's Portrait of Wally. She had no choice but to give in to this demand. Bondi then managed to emigrate from Vienna to London and opened another gallery there. After the war, she sought restitution of her gallery, which was successful, although ironically, she was ordered to pay Welz for the so-called improvements he had made to the gallery that he had taken from her. But Portrait of Wally was not restituted to Bondi. It turned out that the US forces had recovered Wally, but the Austrian government mistakenly returned it to the family of another Jewish victim of the Holocaust, whose family sold the work to the Gallery Belvedere in Austrian National Museum. Enter Dr. Rudolf Leopold. A collector and expert on Schiele, Leopold had visited Bondi in London, and she asked for his help in retrieving Portrait of Wally. Pretending he was unable to help her, Leopold then went straight to the Belvedere and acquired the work for himself. Bondi eventually discovered that Leopold had double-crossed her, and she tried for years to get the work back. And then it showed up at MoMA. Bondi asked the museum's director, Glenn Lowry, to return the work to her, and he refused. And then on January 7, 1998, the Manhattan District Attorney served a grand jury subpoena on MoMA to secure the painting as allegedly stolen property. What ensued, and you'll see that this is a typical pattern, was 13 years of litigation in the United States. The United States government contended that Portrait of Wally was stolen, and that therefore it was imported into the US and would be exported from the US in violation of US law. The Leopold and MoMA actually contested whether the work was actually stolen, suggesting that Bondi voluntarily parted with it before she fled the country. The Leopold also asserted some of the other technical defenses that we will see as we look at later cases. That US courts could not second-guess the official acts of another government was one, the so-called act of state doctrine. And in this case, Austria's post-war restitution of this work to the wrong family, that we couldn't challenge that, and that the claim was brought too late. So finally, in 2010, with the death of Leopold, the case was settled before trial. The painting would be returned to the Leopold Museum, and they would pay the Bondi heirs $19 million US. Apart from the result, though, this case got enormous publicity. Front page in the New York Times, big article in the magazine section, and that the publicity that this case garnered in 1997 and 1998 brought the issue of Nazi looted art into sharp focus for many people, particularly US museums. So with the bringing of the Portrait of Wally case and the articles coming out about looted artworks, US museums started to get a little worried. As I mentioned before, U.S. museums were active in acquiring works from European dealers in the post-war period. They were also the recipients of works from donors who themselves had acquired the works after the war. So this increasing public attention toward Nazi looting caused museums to ask questions about the art and objects in their collections, with gaps in provenance between 1933 and 1945. So in 1997, the Association of Art Museum Directors, or the AAMD, and this is an association of actual directors of museums, not the museums themselves, the AAMD convened a task force on the spoliation of art during the Nazi World War II era from 1933 to 1945, and issued its report on June 4, 1998. And that report directs its member museum directors to do several things. First was to conduct research regarding existing collections, find out what you have. The second was to provide public access to museum records. The third is to take action upon discovery of unlawfully confiscated works of art. And then finally, to respond to any claims against a museum responsibly and with respect for the party making those claims. And then in late 1998, as Antonia said, the U.S. Department of State hosted the Washington Conference on Holocaust-era Assets, the first comprehensive international conference to address assets stolen by the Nazis. Over 40 countries attended, and the result of the conference was the publication of the Washington Conference Principles on Nazi-Confiscated Art. These principles are not a treaty, and they're not legally binding, but they were and are considered aspirational and have been widely embraced. And as you will see, the conference principles were heavily influenced by the AMD guidelines that we just reviewed. Let's briefly just take a quick look at the core principles that were published after the Washington Conference. There are a number of them, but I'm just going to look at the ones that are most relevant for us. And the first one was that art that had been confiscated by the Nazis and not subsequently restituted should be identified. That's the research part. Relevant records and archives should be open and accessible to researchers in accordance with various guidelines. Third, pre-war owners and their heirs should be encouraged to come forward and make known their claims to art that was confiscated by the Nazis and not subsequently restituted. And then finally, and this one really is most central, if the pre-war owners of art that is found to have been confiscated by the Nazis and not subsequently restituted to them or their heirs can be identified, steps should be taken expeditiously to achieve a just and fair solution, recognizing that this may vary according to the facts and circumstances surrounding a specific case. And one of the most important concepts that came out of the Washington Principles is this urging of parties to reach just and fair solutions. Around the same time, the American Alliance of Museums, and this is an organization of museums that are members, came out with their own guidelines. And in the interest of time, I'm going to go through these a little bit quickly because they echo what we've just seen. But just so you see that the museums themselves have promulgated their own guidelines that say they should research. And the second one is important in a way because it recognizes that with the expansion of online access to the collection of information, museums should make their research public and online. And that we'll come back to that in a second. And that any claims of ownership should be addressed openly, seriously, responsibly, and with respect for the dignity of the parties involved. And one of the things also that I want to call your attention to is that the guidelines say that the museums, if someone comes forward, should attempt to settle, and they should waive legal defenses if appropriate. Okay? So you will note that there's a reference in these guidelines to expanding online access. And this is all happening, remember, in the late 1990s. And of course, the internet is growing, And it starts to become easier to have databases that are accessible and searchable. And one of the first of these databases was the Art Loss Register. And the Art Loss Register, or ALR as it's sometimes called, was an outgrowth of a project started by the International Foundation for Art Research, or IFAR, which started publishing a stolen art report in the mid-1970s. By 1990, the frequency of these reports started to outpace IFAR's resources, so they needed to outsource this work. And Art Loss Register, which was a for-profit company, founded in 1990 by Julian Radcliffe, formed a partnership with IFAR and the major auction houses who needed a centralized database that was easily accessible. And ALR allowed users to both register claims on the database and to search for claims. This, frankly, revolutionized the process of doing real-time due diligence on works for sale. And it also started to facilitate legal claims. Okay, so after the adaptation of the Washington Principles and the guidelines by the AAM and the AAMD and the availability of searchable databases, it would seem like smooth sailing for heirs of Nazi-looted art as we ended the 1990s, and those people sought to restitute work from museums, but as we'll see, it didn't really happen that way. Two cases, Toledo Museum of Art versus Ullin and the Detroit Institute of Art versus Ullin, illustrate the ineffectiveness of the museum guidelines when it comes to claims for major works of art. Both cases involve the heirs of Martha Nathan, a German Jewish woman who had emigrated to France in 1937 and then to Switzerland in 1939, just before the outbreak of the war. Nathan's husband, Hugo Nathan, was a prominent art collector, and upon Hugo's death in 1922, Martha inherited all of his art. In May 1938, Martha returned to Germany to sell her house, where she was required by the Nazi government to turn over the 6 paintings remaining in her home. Many other works of art, including the art at issue in these two cases, had already been shipped by Martha to Switzerland. In 1938, she sold Paul Gauguin's Street Scene in Tahiti to a trio of German and French Jewish buyers for 30,000 Swiss francs, approximately $6,900 US. And that trio then sold the work to the Toledo Museum months later for $25,000, substantially more than they paid her for the work. The museum has had the work on display since then, with Martha Nathan listed as the prior owner. After discussions with the museum did not result in an agreement, the museum affirmatively sued Nathan's heirs. This was viewed as an aggressive move and very much contrary to the guidelines promulgated by the AAM and the Washington Principles, and they did this in order to choose the forum where the case would be litigated, which they knew would be more favorable to them than if they waited to be sued by the heirs. The heirs argued that Nathan was compelled to sell the work at a below market price because of the financial stress she was under, because of property she lost in Germany and her uncertain status in Switzerland. The museum argued that Nathan sold the work to people she knew while she was not in Germany, nor was the work in Germany. The museum also argued that Nathan made claims for property and other artwork after the war, but didn't make a claim for the Gauguin. The implication being that she did not think that this work had been taken from her. Finally, the museum argued that the work was on public display for years and that nobody had asserted ownership in the work. Ultimately, the Ohio court ruled in favor of the museum, not on the merits, but on the defense that the claim was barred by Ohio's 4-year statute of limitations and by the doctrine of laches, which I will explain in a minute. But again, remember that last guideline that we saw, that the museum was supposed to, the museums are supposed to voluntarily, where appropriate, waive technical defenses, and this case was litigated almost entirely on the technical defense of statute of limitations. The heirs, by the way, met the same fate with the same lawyers and the Detroit Institute of Arts sued them affirmatively as well, with the same ruling in favor of the museum based on statute of limitations. Statute of limitations is one of the common defenses that comes up in any Nazi-looted case in the United States. Put simply, every state, and we have 50 of them, has statutes of limitations for almost every kind of claim, maybe except for murder. And it basically says, for this kind of claim, you have X number of years to bring your claims. Usually claims for recovery of property are 3 years or sometimes 6 years, either from the date that the work was stolen or from the time that you discover that it was stolen. And if you don't bring your claim within that period of time, you're out of luck. In addition to that, sometimes states have very long statutes of limitations. New York, for example, has an incredibly long statute. And so what a court can do is if a plaintiff or someone an owner doesn't come forward soon enough, even if they come soon enough to be within the statute of limitations, the court can still say, you know, you waited too long, things have changed, the possessor is in a worse situation because of the passage of time, maybe because a witness or two has died, and therefore we're going to rule against the owner on the doctrine of laches. That's all I'll say about that, but it comes up a lot. So the next case, which also turns on laches, is Bachelard versus Vavra. And Bachelard, and this was a fairly important case out of the Second Circuit in New York, involves Fritz Grunbaum, who was a well-known Jewish cabaret performer. And starting in the 1920s, Grunbaum amassed a well-known art collection, especially of Austrian modernist works, which were featured in numerous catalogs and exhibited. The collection came to include over 400 pieces, including 80 by Egon Schiele. One of the works that Grunbaum owned was the 1917 drawing, Seated Women with Bent Left Leg Torso, featured on the right. The entire collection disappeared during the Nazi period. And in the early 1950s, approximately 25% reappeared on the art market through the Swiss art dealer Eberhard Kornfeld. So in 1938, Grunbaum was arrested as a political undesirable and sent to Dachau, where he died in 1941. His wife Elizabeth was ultimately killed in another concentration camp. The court found that the Seated Woman drawing was eventually sold to the Gallery Gutekunst in 1956 by Elizabeth's sister, which later that same year sold it to the Galerie Saint-Étienne. Bachelard, the possessor here, purchased the work from that gallery in New York in 1963. In 2004, Bachelard put the work up for auction at Sotheby's in New York, and then Leon Fischer and Milos Vavra, as heirs to Grunbaum, asserted ownership to the work, and Sotheby's halted the sale. Bachelard then sued in New York for a declaration that he was the rightful owner. Unusual for restitution cases, there were actually 2 trials on the merits in New York. After the first trial, the court ruled for Bachelard, applying Swiss property law. And under Swiss law, the court found that Bachelard had obtained good title to the work as a good faith purchaser. And I'm going to come back to that in a second. On appeal, however, the appellate court found that New York property law, not Swiss law, should have been applied, which would be much more favorable to the heirs. However, after a second trial, the court again found for Bachelard, based on the doctrine of laches. In essence, that while the claim was within New York's rather long statute of limitations, the heirs waited too long to assert their claim, and because potential witnesses had died, that had prejudiced Bachelard. And one of the things that comes up, and we'll see it again in a later case, is what law do you apply in cases like this? Do you apply the law of the forum where the case is being litigated, or do you apply the law of the European country, either where the work was taken or where the person was at the time the claim arose? And usually, European law, whether it's Swiss, Spanish, French, is much less favorable to an original owner than New York law. And I'll leave it at that for the moment. And so because so many cases where the heirs of victims were unable to recover Nazi-looted art because of statute of limitations defenses, the United States Congress passed the Holocaust Appropriated Art Recovery Act of 2016, commonly known as the HERE Act. And what the HERE Act did was to create a nationwide statute of limitations for recovery of Nazi-looted artwork. The statute of limitations was going to be 6 years from actual discovery of identity, location, and the claimant's possessory interest. So you needed to both know who had the work and that you had an interest in the work, and that sometimes isn't known for a long time. The HERE Act applies to pending cases at the time the act was passed, not past ones. It leaves the defense of laches undisturbed, but one of the things that the HERE Act kind of trades off is that it sunsets on January 1, 2027. So until 2027, the hope was that more claims would be able to be brought and not be defeated by statute of limitations defenses. But in 2027, under this law, that extension is going to disappear. Okay. And the effectiveness of the HERE Act is nicely illustrated by a decision after its passage with a happier ending for the heirs of Fritz Grunbaum. Like the Bacalar case, this case involved two drawings by Egon Schiele, woman in a black pinafore and woman hiding her face. Remember, the Nazis confiscated the art collection of Viennese cabaret singer Fritz Grunbaum, who was arrested in 1938 and sent to Dachau. And while in Dachau, he was forced to sign a power of attorney which authorized his wife, Elizabeth, to file a statement of his assets, as Jews were required to do starting in 1938. Fritz Grunbaum died in 1941, and Elizabeth the year later. In 1956, Elizabeth's sister sold these two works, along with Grunbaum's other works by Schiele, to the Swiss gallery I mentioned before. In 2004, Grunbaum's heirs and the Art Loss Register wrote to Richard Nage, a private art dealer and expert in the work of Schiele, searching for works belonging to the Grunbaum estate. Years later, in 2013, the same dealer actually acquired two of these works. And 2 years after that, Timothy Reif and David Frankel, as heirs of Grunbaum, filed a lawsuit against Nage after discovering the two works for sale in an art fair. The New York court rejected a statute of limitations defense and liberally applied the HERE Act, highlighting its purpose, and that is to ensure claims for Nazi loot are not dismissed due to stringent evidentiary burdens when only a fragmentary historical record ravaged by persecution and war is left. In addition, the plaintiffs here were also awarded money damages for the period while the work was unlawfully detained from 2015 to 2018. And if you want, you'll be able to see these works because they are being sold on behalf of the Grunbaum heirs at the Christie's November auction this year. So there are really three categories that these cases generally fall into. Outright theft, the Gestapo bangs down the door, comes in and takes the work. Sales under duress, which was very typical, where Jews had to declare all of their assets, and then they were visited by various functionaries and essentially made offers that they couldn't refuse. I'm thinking about The Godfather. And flight goods. And the flight goods really fall into the category that we saw with Martha Nathan, where someone's out of the country, they're not in immediate danger, but they've sold their works because they were Jewish, because they had to leave, and because they were in need of funds. Okay. Zuckerman versus Metropolitan Museum of Art is a case that illustrates how courts actually decide whether a sale is under duress. Paul and Alice Leftman, who were refugees from Germany, were trying to escape from Italy to Switzerland. They sold The Actor by Pablo Picasso in 1938 at below market value to cover the expenses of the passage out of Italy. Eventually, the work was donated to the Metropolitan Museum in New York, which then falsified the provenance information, eliminating the prior ownership of the Lefmans. And one of the questions that the court needed to decide is which law to apply in answering the question about whether the work was actually sold under duress. Should they apply Italian law, where the duress would have occurred, or New York law, where the work was located? Well, the court looked at both and found that there was no duress under either New York or Italian law. And in reaching its decision, the court reasoned that one, the work was not seized by Nazis, and two, it was a private transaction, and there was no pressure applied by the buyer. And so in this case, the museum won. So the last three cases I'm going to talk about all involve difficult legal principles involving foreign sovereigns. And these cases address whether sovereign nations or the museums they control are immune from lawsuits in the US, whether the US courts must give deference to governmental acts of foreign nations, and whose law applies. All these cases involve museums. So this is probably the most famous of the restitution cases. There was even a movie made about it. And this is, of course, the case about the extraordinary efforts of Maria Altmann, who escaped Nazi Germany and emigrated to the US to recover Gustav Klimt's portrait of her aunt, Adele Bloch-Bauer, featured here in the painting and on the right, along with several other paintings by Klimt. And so if we go back to the turn of the last century, Vienna was one of the great cosmopolitan capitals. Among the most prominent Jewish families of the time was the Bloch-Bauer family, headed by the sugar magnate Ferdinand Bloch-Bauer. Ferdinand's wife, Adele, reigned over a glittering salon attended by Vienna's leading artists and intellectuals. A frequent guest at her salon was Gustav Klimt, then the most sought-after painter in Austria. Between 1903 and 1907, Klimt painted Adele in a gold-flecked portrait called Portrait of Adele Bloch-Bauer. There are actually two of them, and this is one, which was sometimes referred to as the Austrian Mona Lisa. In addition to this portrait, the Bloch-Bauers owned at least 6 other Klimt paintings. In 1925, Adele Bloch-Bauer died, and in her will, Adele asked that her husband Ferdinand bequeath the Klimt paintings to the Austrian gallery upon his death. Later, it was determined that the Klimt paintings actually belonged to Ferdinand rather than Adele, and Ferdinand left his entire estate to Maria Altmann, his niece, and several other heirs. In 1938, Germany annexed Austria, and Ferdinand, because he was Jewish, fled Austria, and the Nazis confiscated Ferdinand's home, business, and artwork, including the Klimt paintings. The paintings were then divided up and transferred to various German places, and Adele Bloch-Bauer portrait ended up in the Austrian gallery, Austrian museums. After the war, in 1946, the Republic of Austria enacted a law declaring all transactions motivated by Nazi ideology null and void. However, the Republic often required owners to repay the purchaser the purchase price before an item was returned, making restitution very difficult. The government also imposed heavy export duties, which also complicated the efforts of heirs who were obviously no longer living in Austria. In March 1948, the heirs' Austrian lawyers sought to recover property stolen from Ferdinand during World War II. The heirs' lawyers sought the gallery's support in obtaining export permits for many of Ferdinand's artworks, and in exchange, the heirs' lawyers signed a document agreeing that Ferdinand, upon his death, wished to follow the wishes of his deceased wife to donate the Klimt paintings to the gallery. In 1998, a journalist discovered documents revealing that the gallery knew that neither Adele nor Ferdinand had donated the Klimt paintings to the gallery. Subsequently, Austria passed a new law under which individuals who had been coerced into donating artworks to state museums in exchange for export permits, like them, could reclaim their property. So Maria sought recovery of the Klimt paintings under the new law. Austrian officials agreed to return certain Klimt drawings and porcelains, but declined to return the Klimt paintings, maintaining falsely that Adele had left the works to the gallery in her will. So in August 2000, Maria Altman filed a lawsuit in federal court in California, seeking recovery of the Klimt paintings, which were unquestionably stolen by the Nazis. Her complaint alleges multiple claims and violations of Austrian, international, and California law. But the threshold question for the court was, how does a California court have jurisdiction over a gallery in Austria owned by the Austrian government? Altman asserted jurisdiction under the US law called the Foreign Sovereign Immunities Act of 1976, sometimes called the FSIA. Now, sovereign immunity is a general principle dating back to medieval times, that the sovereign, and now meaning the state or country, cannot be sued without its consent. And that's a very broad principle that has been interpreted by hundreds of years of jurisprudence, and there are many exceptions to the rule. The FSIA was enacted in the US in 1976, and it contains a list of these recognized exceptions, most of which concern commercial activities. But the FSIA has something known as the expropriation exception, which says that if the claims concern rights and property taken in violation of international law, and the foreign sovereign uses the property in commerce, then it can be sued in the United States. Austria's principal argument in the Altman lawsuit was that the U.S. Foreign Sovereign Immunities Act, by which Altman sought jurisdiction, was not enacted until 1976, and therefore could not be applied to a situation that took place years before. Altman won her argument in the trial court, and Austria and the US government, which sided with Austria in this case, took the argument all the way to the US Supreme Court, which in 2004 ruled in Altman's favor. Of course, that just allowed Altman to move forward with her lawsuit. Austria had indicated that it would not respect the US court's decision, and Altman agreed to submit the dispute to a panel of 3 Austrian arbitrators. The panel, surprisingly to many, ruled in favor of Altman, and all the Klimt paintings were returned, which after a brief exhibition at the Los Angeles County Museum of Art, this painting was sold by Altman for $135 million to Ronald Lauder, who placed it in his New York museum. And 4 other works by Klimt were later auctioned for nearly $193 million, bringing the total for Altman and some close relatives to some $326 million. Not a bad day's work. So we see in Altman an interpretation of the FSIA allowing the US court to assert jurisdiction over an instrumentality of Austria. The other area where plaintiffs have not been very successful is a related doctrine called active state. And we see this play out in another case called Marie von Sacher versus the Norton Simon Museum of Art. The paintings in this case are Adam and Eve by Lucas Cranach the Elder, a pair of Renaissance paintings on wood panels. And this case involves the very tragic story of one of the great Dutch art dealers, Jacques Goudsticker. In 1931, Goudsticker purchased the Cranaches from the Soviet Union at an auction in Berlin, and there are a lot of questions about that. Jacques and his wife, Desi, who were both Jewish, left the Netherlands hastily just after the Germans invaded in May 1940. On the eve of his departure, he met with his employees and asked 2 of them, Jan Dieck and his son, to take care of his collection of roughly 1,200 works of art. Jacques and Desi departed on one of the last ships to leave occupied Netherlands. And on that voyage, Jacques went out on deck at night to smoke a cigarette and tragically fell through a hatch to his death. Desi eventually made it to the United States. Shortly after their departure, Hermann Goering and Alois Miedel, a German banker and notorious art thief for the Nazis, actually took over Gottsticker's gallery. And this is the way the Germans did it, right? They didn't just come in and take the paintings. They actually came in and held shareholders meetings as if they were now the owners and were going to do this legitimately. So they held shareholders meetings, and then they spread rumors that the gallery was on the verge of bankruptcy, thereby allowing them to purchase the entire gallery and the real estate in which it sat for a very modest sum of money. Goering then took possession of the art collection and had 780 of the works shipped to Germany, with 300 of the most valuable sent to his estate. One of the things that Jacques left behind, though, was a small book with a list of the roughly 1,200 works of art that they left behind. So unlike many cases, there was clear documentation of the works that were stolen by Goering. After World War II, the Dutch government created systems of restitution and reparations for losses incurred by citizens at the hands of Nazis. By 1946, the Allied forces had recovered much of the artwork from the Miedel and Goering theft, including these Grenaches, which were turned over to the Dutch government. Desi then returned to the Netherlands and sought restitution of other property, but for complicated economic reasons did not pursue the Grenache works, which remained with the Dutch government. And then, in the 1960s, a man by the name of George Stroganoff Sherbatov, I love his name, claimed that the Soviet government had stolen the painting from him and that he was the rightful owner of the Grenaches that had been, as you remember, purchased at the Berlin auction in 1931 by Jacques. In 1966, Stroganoff and the Dutch government reached a settlement in which Stroganoff bought the Grenaches from the Dutch government in exchange for dropping his restitution claims. In 1971, Stroganoff sold Adam and Eve for $800,000 to the Norton Simon Museum, where they have been on display ever since. So in the 1990s, Mireille von Sacher, the only living heir of Jacques and Desi, filed a petition in Austria under an Austrian restitution law seeking restitution of the paintings from the Goering theft, including the Grenaches. In 1999, the Dutch Court of Appeals denied von Sacher's petition, finding that the Gutsticker firm, post-war, had made a conscious and well-considered decision to refrain from asking for restoration of rights with respect to the Goering works. In 2001, the Dutch government created a new restitution committee, as a number of countries in Europe had done. And in 2004, Van Sacher petitioned the restitution committee for over 200 artworks from the Goering theft that were still in the hands of the Dutch government. The restitution committee concluded that although Van Sacher's claims for these artworks had actually already been settled, all the paintings in the possession of the Dutch government from the Goering theft would nevertheless, even though they weren't obligated to, be returned to von Sacher. But because the Grenaches were no longer in the Dutch government's possession, they were not returned. Von Sacher then commenced the lawsuit in federal court in California, where the Norton Simon is located, a lawsuit that would take the next 11 years to resolve. And her claims were basically that the museum had not acquired good title to the paintings under US law because they were stolen from Gutsticker, and then everybody else after Gutsticker had defective title, and that she as heir has superior title to everyone else. The first round of litigation involved California's statute of limitations that they had passed specifically for Nazi looted art. And California basically said, with respect to Nazi claims, we're not going to have a statute of limitations. You can come in anytime you want. The Norton Simon challenged this and said that it was unconstitutional, and the courts agreed. California then changed their statute and fashioned a new statute that was eventually upheld, even though the Norton Simon challenged that again. Ultimately, Norton Simon argued, and the courts agreed, that Jacques Goudsticker's heirs, by which their successors today are bound, had missed the deadline for filing claims for the Goering seizure, and the US court was not going to question that decision. in application of the active state doctrine. One of the arguments that the Norton-Simon made, which was heavily criticized, was that Marie von Sacher was an inequitable plaintiff who shouldn't be entitled to recover because it was alleged that her father was a Nazi. This attack obviously had nothing to do with the substantive rights in the case. So now, two unquestionably looted works of art hang in a prominent American museum in California. And the very last case that I'd like to discuss in my couple of minutes left is one that's very close to home, I know. It's the case involving a work by Camille Pissarro that sits a few kilometers from this venue. And this is the case of Cassirer versus the Thyssen-Bornemisza Collection Foundation. In 1990, Paul Cassirer, a member of a prominent German Jewish family owning an art gallery and publishing house, bought the Camille Pissarro from Pissarro's agent. The painting is Rue Saint-Honoré in the afternoon effect of rain. The painting was passed down within the Cassirer family, which is how Lily Cassirer inherited the painting. Lily displayed the painting in her Berlin home, which is pictured there on the left. However, after the Nazis came to power in Germany in 1939, Lily needed to escape the country. As a condition to her exit visa from Germany, Lily surrendered the painting to the Nazis. Lily and her grandson Claude Cassirer fled to the US. The Cassirers later tried searching for the painting, but without success. After World War II, it turns out that the painting also arrived in the US, where it was sold and sat in a private collection in St. Louis from 1952 to 1976. In 1976, Baron Hans Heinrich Thyssen-Bornemisza, I still can't pronounce that. I try. Bought the painting. From 1976 until 1993, the Pissarro hung in the Baron's residence in Switzerland. And in 1993, the Baron sold much of his art collection, including the Pissarro, to the foundation. And as you know, the painting is hanging on the museum wall, a short walk from where we sit. I saw it yesterday. In 1999, Claude, now the sole Cassirer heir, as Lily had passed away, learned that the Pissarro was housed in the collection of the foundation. The Cassirers sued the foundation in California to recover the Pissarro, arguing that the Cassirer family was the rightful owner. And because the foundation is an instrumentality, as we call it, or state-controlled entity of the Kingdom of Spain, to establish jurisdiction, the Cassirers invoked, of course, the Foreign Sovereign Immunities Act of 1976. The lower courts held that the case could move forward under the Foreign Sovereign Immunity exception for expropriated property, a determination that is no longer an issue in the case. The question then became, under what principle should the court determine whose property law would govern ownership to the painting? Because the answer to that question very likely will determine the outcome of the case. If it's US property law, it's probably going to go in favor of Cassirer. If it's Spanish law, it's going to probably go in the direction of the foundation. So to determine what property law governs the dispute, the lower courts needed to determine what choice of law rule to apply. And a choice of law rule provides a way of selecting which jurisdiction's law governs to determine who is liable. And while the Cassirers argued that California's choice of law should apply, the foundation argued that a choice of law rule deriving from a federal rule should apply. The lower courts concluded that the federal law ought to apply, and therefore the property laws of Spain should govern the dispute. And applying Spanish property law, the lower courts determined that the foundation was the owner of the painting. The Cassirers appealed the decision to the US Supreme Court. And in April of this year, in a unanimous decision, which is very rare for our Supreme Court these days, the US Supreme Court held that in a Foreign Sovereign Immunities Act case, raising non-federal, that is, state claims against a foreign government, a court should determine the substantive law, which law applies, by applying the same choice of law rule applicable in a similar suit against a private party. Here, the Supreme Court said that the lower court should have applied California's choice of law rule and not some federal common law rule. So, 16 years after this case was filed, it will now go back to the appellate court in California, where the parties are right now submitting papers as to whether applying California choice of law rules, whether California or Spanish property law should govern this dispute. So stay tuned.
Thank you, Stephen. I'm glad I'm not a lawyer. All very complex. So to end on a slightly more optimistic note, I will discuss how these cases can be resolved in non-litigious ways, and looking at a collection of paintings from the Yale Art Gallery, at the risk of sounding trite, how it's not too late to do the right thing. And we can really see this in terms of how Yale, the art gallery, responded to the Washington principles in the late 90s, early 2000s, and how that initial response has evolved over the last 20 years. So in 1981, the Yale Art Gallery received the first of over 40 loans from the Schaefer Collection, a collection of European art spanning the 16th and 17th centuries through early 20th centuries. We can see highlights from the collection here on the screen, and you might recognize a few of them from the paintings that I was discussing earlier. The Schaefer Collection had been formed in two parts. It was first collected by Dr. Herbert Schaefer as a young man in Berlin in the 1930s, and later, after much of his collection was lost or destroyed at the end of the Second World War, he started collecting again with his wife Monica on the European market in the 1960s through 1990s. By the mid-1990s, the Yale Art Gallery had over 35 paintings on loan from the Schaefers, and in 1998, an exhibition highlighting the collection was mounted. Concurrently, a catalog of the collection was published, describing each painting along with select ownership, publications, and exhibition history. Although provenance research into the ownership history of objects, is ideally one of the fundamental art historic lines of inquiry in object-focused studies that occur in collecting institutions, at the time of the earliest Schaefer loans, little was done to investigate provenance at Yale. Indeed, in the collection catalog of the Schaefer collection, not even the immediate origins of many of the paintings were reflected, i.e. the tradespeople and auctions where Herbert and Monica acquired and from whom they would often send works of art directly to Yale. Questions, furthermore, were even less seldom asked regarding this wide-scale loss and plunder that occurred across continental Europe between 1933 and 1945. We can see here on the screen the provenance for the Brunswick monographist Brothelstein, the Lankaransky painting I discussed earlier. At left is the provenance as it was published in 1998. At right, this is how we publish it today, showing the full ownership history and the movement of the painting from Vienna through across Austria to the different repositories, to Munich, and finally back to Vienna and return to the Lankaransky collection. Sorry. As we learned from Stephen, the Washington Conference principles saw an increase in attention on Nazi-era spoliation, and indeed, the Yale Art Gallery was one of those collections to garner such attention. In 2000, one of the paintings on loan from the Schaefer collection was one of the many objects which received a restitution claim. Again, we'll see the Gustave Courbet's The Great Bridge, formerly from the Silberberg collection. Although the Silberberg ownership had been resolved in 1970, the 2000 claim was from another Jewish-German-Czech collection, the Weinmann family, who had lived in Berlin. The claimant, Erich Weinmann, alleged that the painting had been owned by his mother, Josephine, and her family in pre-war Berlin. Remarkably, she had acquired it at the 1935 forced sale of Max Silberberg. Similar to the Silberbergs and so many others, the Weinmann family were either forced to flee Germany or persecuted by the Nazis and died in death camps. The Courbet was thought to have been confiscated from their villa and disappeared. Despite attempts to identify and recover the painting in the post-war period, it was not until it appeared at Yale that it was recognized by a family friend and the family stepped forward. An exceedingly complex case due largely to an almost complete lack of documentation on both sides. The Weinmann's claim was on the basis of memory, Erich having seen the painting hanging in his mother's salon. Dr. Schaefer, in turn, had no records from his purchase of the piece from what he says was in the late 1930s from a dealer and friend in Berlin, from whom very few records survive. Although there was very clear record of the Weinmann's family flight and persecution, there were no actual records indicating that a theft of the painting had occurred. The research was further muddied in that several versions of the painting had been identified by scholars. During the course of research, revelations also came out about Dr. Schaefer's own role during the Nazi period. Allegations were made that he had been a member of the SA, or Brown Shirts, a paramilitary unit within the Nazi Party. Moreover, questions were asked as to how a young law student from little means, his father had been a chauffeur, acquired this wealth to buy pictures of the caliber of the Courbet. Ultimately, however, following the hiring of two external independent researchers, one on each side of the claim, extensive negotiations, and as Stephen described, in part to avoid this lengthy litigation, the parties ultimately came to a just and fair resolution in the spirit of the Washington Conference principles. The painting was placed on temporary loan with Erich Weinmann until his passing. Following this, facilitated by a joint donation between the Schaefers and the Weinmann parties, ownership of the painting was transferred to the gallery and it entered its permanent collections. One would think that after this, the Yale Gallery would have learned their lesson and implemented due diligence and provenance research procedures for anything in coming to the collection, but following this claim, although there was a very perfunctory review of the Schaefer collection, little was done until Monica Schaefer's passing in 2019 and the formal bequest of the collection to the gallery and the start of my position in January 2020. In light of the sensitivities surrounding the Schaefer collection, but moreover recognizing where and when the couple were collecting, again, the post-war European art market, the nature of the collection, chiefly early modern Dutch and Flemish paintings that we know were coveted by Hitler, Göring, other dealers involved in the spoliation of Jewish property, and that finally, as is often said in the provenance research field, new information frequently comes to light. The decision was, I think, obviously made to undertake rigorous provenance research on the collection as part of acquisition. This decision also occurred as the gallery began implementing stricter due diligence standards and a checklist system for all objects incoming, whether by purchase, gift, or loan. This process normally occurs before we acquire an object in order to ensure that there are no claims as to legal title or ethical concerns regarding ownership. For the Schaefer collection, however, after careful consideration, an exception was made. We moved forward with acquiring the objects and pursued research following, absorbing full responsibility and acknowledging that we would resolve any issues should they come to light. The core decision behind this was in an aim for transparency. At the gallery, we publish all accessioned objects and loans on our collection site with known provenance information. Acquiring the Schaefer collection, but not formally accessioning them, the objects would disappear from the public domain. In this instance, we felt it was important to make the objects and their ownership histories as publicly as accessible as possible. Due diligence checks quickly showed that one of the paintings, a Rhine landscape by Jan Griffier, indeed was a loss during the war from the Kunsthistorisches Museum in Vienna. The painting was published in post-war inventories of missing works of art from Austrian collections and registered by the Republic of Austria in post-war claim files with the US Army. The painting was furthermore registered on the German Lost Art Foundation's database, lostart.de, which documents cultural property lost, looted, or displaced during the Nazi period. Continued research, which included alerting the museum to our discovery and consulting with their archivists in Vienna, showed that the painting had previously been part of the Austrian imperial collections. You'll recognize the image earlier from this evening, which shows paintings currently in Vienna and those still missing that were lost in the Reichschancellery at the end of the war. Indeed, this painting had been sent in 1938 as a loan and put on display in Berlin. In August 1944, at the order of Hitler, the painting was transferred to an air raid shelter in the basement of the Chancellery, and at the end of the war, during the Battle of Berlin, the last holdout of German forces, it was presumed destroyed. And we can see here on the screen an inventory of the painting from the Kunsthistorisches Museum's collection, where it describes the movement of the painting. Part of the Gemäldegalerie Gallery, one of the early acquisitions, on loan to the Reichschancellery in 1938. 1945, disappeared, and then officially declared lost in 1973. An annotated copy as well of the collection catalog. You can see very emphatically in the corner, it describes that the painting was burnt with an exclamation point. Continued research was unable to establish the exact fate of the painting after this time, however, and until it appeared on the London market, where it was bought by the Schaeffers. While the provenance between 1945 and 1991 remained unknown, the documentation provided by the museum in Vienna showed that the painting had been neither restituted nor recovered, and the gallery unequivocally concluded that the painting had been unlawfully transferred in Germany. Looking to the AAM and AAMD guidelines on Holocaust and World War II era provenance, which Stephen described, although this was not strictly a Holocaust loss, a deaccession for transfer proposal was nevertheless made to the gallery's governing board and to the university, and a unanimous vote was made to deaccession the painting in order to return it to Austria. The proactive, collaborative, transparent investigation into the Griffier reflects a significant cultural shift and approach to collection stewardship here at the gallery. It comes at a crux in our collecting practices, where we're carefully and thoughtfully considering the origins of art objects and informing these decisions through conscientious, thorough, and responsible research. The Schaeffer collection as a whole, and here are a few samples on the screen where research remains ongoing, where there are gaps in ownership between 1933 and 1945, red flag names such as Goering or sensitive victim names. The modern painting all the way at the left was in a Berlin collection in 1932. The next thing we know is that it was acquired by Dr. Schaeffer sometime in the late 1940s. The painting in the middle, similarly, was acquired at a 1944 auction in Brussels for Goering, and then it disappeared until it was acquired from a dealer by Dr. Schaeffer in 1973. The last painting, again, was on the Berlin market before mysteriously appearing with Dr. Schaeffer. These paintings, the other paintings that I've described, I think we can all agree underline the need for this work within collecting institutions, and that 80 years on, questions continue to linger, and that new information comes to light. Thank you.
Thank you both so much, Steve and Antonia, for your presentations and for sharing your experience with us. We have very, very little time. Maybe just time for one question, unfortunately. There's microphones here and here, but unfortunately we just have time for one question. I'm afraid we're on very strict time limits here in the venue. There's a question over here.
Thank you so much, Stephen and Antonia, for your presentation. I just have a comment or a reflection. All this due diligence that is conducted within a museum, with a department devoted to curating and to study provenance, takes a lot of time. And I wonder if this kind of research is also required in a normal purchaser of an art painting. If, for example, something like that that comes up in a case where is a claim of a return of piece that has been purchased by a individual or a private collector, this kind of level of research is also required to them as a due diligence that is expected to be fulfilled. I don't know if I make myself clear about this. I mean, I think that we cannot compare the due diligence that is conducted within a museum to review all his collection and try to construct all the provenance of the pieces with the practical of a collector that is just buying something in a gallery.
Is the question about the trade?
Yeah, the trade and what behavior is expected that private collector should fulfill when it's purchasing something in a gallery or something like that?
I think two different parts to this, private collections and then trade. So I will say, I think in certain areas of the trade, there is this due diligence. I think largely though, within sort of, the bigger name auction houses, bigger venues, bigger dealers, there is this awareness of, the potential risks that come with buying, selling, trading, even displaying works of art. So there are committed teams, for example, Christie's, Sotheby's, that do vet works of art that go in and out of the auction houses. In terms of private collections, I don't know if you have any thoughts about this, Stephen. You have more experience working with private collectors than I do. But certainly, I think, the Schaefer collection itself underlines the fact that collectors perhaps should be doing their own work, their own due diligence. And certainly where we are at this point in time in 2022, there are a multitude of resources and platforms for understanding the objects and where they come from.
Right. I guess I would just say the auction houses have for a long time done extensive due diligence on this and other issues too, money laundering and things like that. Mostly when you get to sort of higher end works of art, and you're talking about Sotheby's and Christie's and maybe Phillips. I think where things can get a little shakier is when you're dealing with lower value works of art that kind of go through auction houses because there are less resources to devote to a small work of art than to expensive works of art. And I think my experience with galleries, at least in the United States, the larger galleries, they're pretty keyed into this. I mean, I think they would not want to be, for a lot of different reasons, would not want to be in the middle of a transaction. That doesn't mean it never happens, but I think they're pretty vigilant.
Well, I'm afraid we've...
economical compensation to the owner of the painting?
So, well, I'll answer that question. Yeah, no, it's in the United States, no. Oh wait, you're talking about the possessor or the rich? Yeah, in the United States, the answer is no, because of the rule that I mentioned that a thief can never pass good title. In European countries, civil law countries, often the answer is yes. But so it kind of depends. But if it's under American law, then basically the possessor is out of luck. Sometimes that possessor may have a claim against a middle party that he or she bought it from, but they're not entitled to any compensation. Pardon?
In Europe, they would be a negotiation.
Probably, yes.
I think also, though, I mean, we were talking about this earlier, I think that underlines seeking resolutions beyond litigation. And, you know, some examples that I've seen that are settled out of court, the auction houses, for example, they do, you know, the ideal is that there is an agreement between both parties, the consignor and the current holder. The object is sold and there's a split of the proceeds. It's going to be 50-50, 40-60, 30-70. But in museums, again, I think, you know, coming to the table sooner, having these conversations, being transparent, proactive, showing goodwill. Although the early Schaefer claim, we ended up on the cover of the New York Times, not ideal, but that was, you know, I think for all parties concerned, a best possible solution where the claimant was able to keep the painting for the rest of his life, and then there was this joint donation to the gallery, something that was settled out of court. And although there wasn't compensation per se, it did avoid these long, lengthy, litigious cases.
Which are incredibly expensive.
Yeah.
And apart from the you know, emotional aspect to it, to litigate a case for 13, 14, 15 years in the United States, very few people have the resources to do that.
Yeah.
It's very difficult.
It's worth mentioning actually that in certain European countries there are commissions or tribunals to which claimants can refer their cases, and they can refer these cases free of charge, and the usual legal rules that would apply in a court don't apply in these tribunals. So those tribunals exist in Germany, in the UK, in France, in Austria and in Holland. But there isn't an equivalent commission, for example, in the US.
We will never have them.
Yeah, and there never will be. I'm so sorry that we have to wrap up now. I'm so sorry we haven't had time for more questions. But thank you all so very much for coming, and thank you to our speakers. It's been such a great pleasure to listen to you. Just before we wrap up, can I also say just a quick thank you to Marta Suarez-Mencilla and to Paloma Cabrera for helping organize this event. And thank you all so much for coming, and I hope to see you at future ADA events. Thank you.